I'm Camille Swanson. Today I'm going to talk about something very, very important if you're a married person in the state of Arizona. First, I am not an attorney, a financial advisor, or tax professional. The information I'm going to share with you today is strictly real estate related. If you have questions about anything I tell you, you should seek counsel with the appropriate professional who is not me. We're going to talk about disclaimer deeds. Disclaimer deeds are filed at the same time as you record your warranty deed, which is a sale deed when you're buying real property in the state of Arizona. Because we're a community property state, that means property is shared equally, 50-50 with spouses. When one spouse purchases a property, it means that both spouses own it together. If the spouses use a disclaimer deed, it changes everything. The disclaimer deed is when one spouse waives their rights to that property. What that means is that they cannot dictate sale, they may not benefit from proceeds of a sale, they may not be able to encumber the property, and then on the other side of that, they may not be responsible for any liability that comes to the property. As far as financial or tax liabilities or other implications. Well, why? Why would you want to have this disclaimer deed? There are many reasons, but ones that come to mind most commonly are for estate planning, because there are implications, tax and financial and otherwise, to holding real estate. And people want to plan appropriately for things like inheritances and gift tax. So people get very creative and come up with lots of options to do that and protect their investments. Sometimes there are financial reasons. Maybe one spouse can't qualify because their credit is bad, or maybe they have too many properties that they own already and it would just be too complicated. Another reason might be because spouses are getting divorced. That doesn't happen very often. Just kidding. Finally, sometimes, and this is kind of a touchy thing, it's kind of just not nice, part of domestic violence or spousal abuse. I'm going to give you some examples of why it might be good to have disclaimer deeds. First off, one spouse in the process of a divorce might decide they don't want their other spouse to have rights to it. Certainly understand that. Everyone wants to make a clean break and move on. Let's just say this is a new marriage and they go into it with yours, mine, and ours. One spouse might want to use their sole and separate property to buy real property for a family member, like a child or a parent. And they don't want to have further disputes down the road between the receiving family member and their new spouse. Sometimes one spouse is just really sneaky. They've got lots of debt. They don't want to share this information with their spouse. And somebody, a debt holder, wants to collect on the money that's owed to them. This might be, I don't know, the IRS, a medical provider, an attorney, maybe it's a contractor. We call those mechanics liens that can be attached to homes if payment is not rendered in a timely fashion. What these folks can do is attach a lien or a judgment to the house, and it would give them the right to the profits before the co-owning spouses would receive a dime. This is serious stuff. Kind of need to pay attention. What does one do? How would you know if there are debts or judgments against a property that you might own? Say you own some property out in another part of the state and you decide, you know what, we can do something else with these funds. Let's sell this property and we want to cash in on this red hot market and use the money to do something else. Maybe invest it in another venture. It would be a very, very disappointing surprise to find out that after the sale of your property, what's left over is very little because there's some unknown judgment or lien attached to the property that one spouse just didn't know about. What can people do? Well, I'm glad you asked that question. There are a lot of remedies and resources. First, start online, which is the easiest place to go. I mean, what can't you find online? For instance, you can go type in your spouse's your spouse's business's name in either the county recorder's website to see if there are any properties owned in the spouse's name or their business name, or if there are any other liens or other things attached directly to the property. Let's just say that there's a federal tax lien. Those ones don't necessarily show up in the county recorder. They actually, if it's a business lien, would be filed with the Arizona Secretary of State. And that website is azsos.gov. And once you get there, you'll want to search for UCC liens. That means that the IRS has gone directly to the Secretary of State to file their lien to put on notice that it exists, and the IRS can collect for up to 10 years. So you definitely want to check into that because that's some serious stuff. The other thing a spouse can do is to set up a parcel watch. You do that with the county treasurer. That website is treasurer.maricopa.gov. There, it notifies all registered parties about any impending liens or potential delinquencies against a property that is in their database. Very, very good resources to have. You definitely want to check those. Okay, so now let's just say time has gone by. You purchased your property a long time ago, and it's too late to go back and do a disclaimer deed because remember, it's only valid at the time the property records when the sale is complete. What does one spouse do if the other is a super, super sneaky fox? Well, if both spouses are on loan and titled and everybody's liable, but one spouse, that's the honest spouse, doesn't want to lose the rights to their property, they can do a few things. If the property is owned jointly in both names, prior to the decree being issued for the final divorce decree, they can refinance the property into their own name and completely remove the other spouse. But it's very important to determine whether or not the date that the lien was recorded predates the decree. That's the kind of thing you want to ask a tax and or family law professional. The next thing is a spouse can have the sneaky spouse sign off on what we call a quitclaim deed. Kind of does the same thing. One spouse ends up waiving their rights after the fact, but it may not be applicable or the best option. So again, consult someone who's qualified to tell you. And then, whatever you do, make sure that it's addressed in the final divorce decree. Otherwise, you know what? The paper might not be worth squat. It would be better you use it to wipe your own butt. I hope that this information was really useful to you. If you've got any questions about property that you are looking to buy or sell as it relates to disclaimer deed, I encourage you to reach out and contact me. I've got plenty of info and or can direct you to the right people who can help.